Thank you for tuning in to Module 3 in the 2025 Municipal Affairs Election Training Program. This module will focus on election finances and contributions disclosure. The nomination period officially started on January 1st, 2025, and you may already be getting questions about finance and contribution disclosure rules from candidates. As a bit of a disclaimer before we start, this video is intended as an introduction and overview of some of the things you need to know as a returning officer. This presentation does not provide a comprehensive review of the legislation and is not legal advice. If you have questions about how the legislation applies to specific facts, make sure to get advice from your legal counsel. If you watched our modules 1 and 2 presentations, you already know that our 2025 training will be delivered in pre-recorded videos and posted to the Municipal Affairs website throughout the election year. If you haven't watched these presentations, please take some time to watch them as they include some important information on resources, roles and responsibilities, election-related resolutions and bylaws, and the nomination process. In Module 3, we'll focus on campaign financing. Module 4 will be posted later this spring, with Modules 5 and 6 coming also later this spring as well. The remaining modules will be made available over the course of spring and summer 2025, in addition to an elections database presentation and specialized training for summer villages. In Module 3, we'll be focusing on election finances and contributions disclosure. Primarily, we'll be focusing on the basics of what candidates need to know as they prepare to finance their campaigns and meet their disclosure obligations. As a returning officer, you are not expected to provide advice to candidates who have specific questions about financing and disclosure rules. However, you will want to be able to provide candidates with high-level information about their obligations under the Local Authorities Election Act. Candidates should get independent legal advice if they have questions or concerns about the responsibilities or the application of the legislation in their particular circumstances. Election finances and contributions disclosure rules are outlined in Part 5.1 of the Local Authorities Election Act. This presentation will provide an overview of the legislation, but again, is not a comprehensive analysis and is not legal advice. All returning officers and candidates should ensure they have reviewed this part of the Act so they understand how the rules apply. Returning officers and candidates should always get legal advice if they have specific questions or concerns about the application of the legislation. Finance and contribution disclosure rules are complex, and there are serious consequences for candidates and contributors who fail to follow the rules. Candidates and contributors have specific duties and responsibilities under the LAEA. Both should understand that there are strict limitations on who can contribute, how much can be contributed, and how funds must be managed. It is especially important for candidates to understand their disclosure obligations.
With the proclamation of Bill 20, the Municipal Affairs Statutes Amendment Act, campaign periods for municipal elections are now 4 years long, starting on January 1st of the year immediately following a general election and ending on December 31st, immediately following the next general election. For the 2025 election, prospective candidates were permitted to begin collecting contributions and incurring expenses as of October 31st, 2024, as long as they had submitted their notice of intent, as required by Section 147.22 of the LAEA. For more information about the notice of intent provisions of the LAEA, please review Modules 1 and 2.
Before contributing, a prospective contributor is responsible for ensuring that they are not prohibited from making the contribution and are not contributing more than the limit prescribed by Section 147.2 sub 2 or sub 3. Every candidate and every person acting on behalf of a candidate shall make every reasonable effort to advise prospective contributors of Part 5.1 of the Local Authorities Election Act as it pertains to contributions.
Please review the definition of campaign expense. in section 147.1, which includes a list of expenses and non-monetary contributions. In Part 5.1 of the LEEA, a contribution means any money, personal property, real property, or service that is provided to or for the benefit of an election campaign of a candidate or a local political party without fair market value compensation from the candidate or local political party. This does not include a service provided by an individual who voluntarily performs the services and receives no compensation. This definition was amended in May of 2025 to add the expenses of local political parties and slates and non-monetary contributions to local political parties. The value of a contribution provided to a candidate, other than money, is the fair market value of the contribution at the time it was provided.
No individual residing outside of Alberta, a prohibited organization, or trade union or employee organization other than an Alberta trade union or Alberta employee organization may contribute to a candidate. Please review the list of prohibited organizations in section 147.1 sub F. In a general election, contributions by an Alberta resident shall not exceed $5,000 in the aggregate to all candidates in a particular municipality in a calendar year during the campaign period. Contributions by Alberta corporations, trade unions, and employee organizations shall not exceed during the campaign period $5,000 in the aggregate to all candidates for election as a councillor in a particular municipality. A candidate may contribute up to $10,000 of the candidate's own funds that are not reimbursed to the candidate from the candidate's campaign account by the end of the campaign period. No candidate or person acting on behalf of a candidate shall solicit or accept a contribution if they know or ought to know that the amount of the contribution will exceed the amounts referred to above, or if they know or ought to know the contributor is not permitted to make a contribution. Anonymous contributions are also prohibited. If an anonymous or otherwise prohibited contribution is received, the candidate or the person acting on behalf of the candidate shall return the contribution to the contributor if their identity can be established, or if their identity cannot be established, pay an amount equivalent to the contribution to a registered charity or to the municipality for which the candidate is running for election. Candidates have several duties and responsibilities under Part 5.1 of the LEEA. A candidate shall open a campaign account in the name of the candidate's election campaign or of the candidate at a financial institution at the time the candidate gives written notice under section 147.22 or as soon as possible after contributions exceed $1,000 in total. If a campaign account has been opened, all contributions of money are deposited into the campaign account. Money in the account shall only be used for the payment of campaign expenses. Contributions of real property, personal property, and services are to be valued. Receipts are to be issued for every contribution and obtained for every expense. Records are kept of contributions and campaign expenses and are retained by the candidate for a period of 3 years following the day of the election to which they relate. And proper direction is provided to the candidate's official agent and any other person who is authorized to incur campaign expenses and to accept or solicit campaign contributions. A candidate who contravenes section 147.3 is guilty of an offense and liable to a fine of not more than $1,000. The gross income from any fundraising function must be recorded by the candidate on whose behalf the function was held. Only residents of Alberta can purchase a ticket or pay for admission for a fundraising event. It is a violation of the Local Authorities Election Act if prohibited persons or entities purchase tickets, pay admission, or offer a reimbursement for the full ticket or admission price. A candidate may borrow money only from a financial institution and shall record all loans and their terms and shall report accordingly to the relevant municipality. Only an individual ordinarily resident in Alberta, a corporation other than a prohibited organization, an Alberta trade union, or an Alberta employee organization may make a payment on behalf of the borrower. This section only applies to the borrowing of money related to the candidate's election campaign.
The requirements for campaign disclosure statements were amended as of May 15, 2025. Please ensure you are referring to the newest version of the LAEA when conducting your election. In the case of a general election, on or before March 1st of each year, a candidate who received contributions in the previous year, including self-contributions from their own funds, shall file with the Secretary, i.e. the CAO, of the candidate's local jurisdiction a disclosure statement in the prescribed form, which is Form 26. Candidates who received contributions in November and December of 2024 were required to file their disclosure by March 1st of 2025. New for this election is a requirement for candidates to file a disclosure statement by September 30th, 2025 if they received contributions between January 1 and July 31st of 2025. The required disclosure due by March 1st of 2026 must include the campaign contributions and expenses for the entire 2025 year. Returning officers should ensure candidates are aware of what needs to be included in a disclosure statement under Section 147.4. It's a good idea to provide this information when the candidate picks up or submits their nomination papers. Provide candidates with Form 26 and recommend that they review Section 147.4 of the LAEA to ensure they understand their obligations. Any individual who provides written notice under Section 147.22 and incurs campaign expenses or receives contributions, including candidates who withdraw, must file a disclosure statement. The municipality must ensure all documents filed are available to the public on a local jurisdiction's website.
If a candidate's disclosure statement in respect of the year in which a general election was held shows a surplus, the candidate, within 60 days after the filing of the disclosure statement with the local jurisdiction, shall, with respect to any amount that is $1,000 or more, donate amount to a registered charity that results in the surplus being less than $1,000, and may, with respect to any amount that is less than $1,000, retain all or any portion of that amount and donate all or any portion of that amount to a registered charity. A candidate who donates an amount to a registered charity must, within 30 days after the 60-day period provided above, file an amended disclosure statement showing the surplus has been dealt with. If a candidate's disclosure statement in respect of the year in which a general election was held shows a deficit, the candidate shall eliminate the deficit within 60 days after filing the disclosure statement with the municipality. For the purposes of eliminating a deficit, a candidate may accept contributions within the 60-day period. A candidate shall not accept a contribution that exceeds $5,000 from any single contributor. Candidates may make a contribution from their own funds that does not exceed $10,000 for the purpose of eliminating a deficit. A candidate must, within 30 days after the expiration of the 60-day period, file an amended disclosure statement showing the deficit has been eliminated. Please also remember that the rules governing campaign disclosure, campaign surplus, and campaign deficit continue to apply to individuals who give written notice under Section 147.22 but do not file a nomination, whose nomination was not accepted under Section 28, who are disqualified, or who become ineligible to continue as a candidate, and for those who are not elected. A candidate who fails to file a campaign disclosure statement within the specified time period is required to pay a $500 late filing fee to the municipality. If the fee is not paid within 30 days, the municipality must send a notice to the candidate indicating the amount of the late filing fee to be paid. Pursuant to Section 147.8, if a candidate fails to file a disclosure statement, the Secretary shall present a report to Council on the day of the first Council meeting after the filing deadline and publish the report or the information in the report on the municipality's website by no later than the day of the Council meeting at which the report was presented. If a candidate files their disclosure statement no later than 10 days after the filing deadline, the candidate is not required to form part of the report to Council. In the case of school board trustees, the Secretary of the school board shall transmit a report to the school board. If a candidate who is sent a notice by the municipality fails to pay the late filing fee, the municipality may file a notice with the Court of King's Bench. A candidate may, within the 60-day period beginning on the day the report or information is published on the municipality's website, apply to the court for relief. There are some further consequences for late filing. Pursuant to Section 22 sub 1.2, a person is not eligible to be nominated as a candidate for election as a councillor or a school board trustee if a report was presented or transmitted under Section 147.8 sub 1 in respect of the person, the court did not dispense with or extend the time for compliance with Section 147.4. Ineligibility is either for 8 years following the day on which the Secretary presented the report to Council or transmitted the report to the school board, or 3 years if the disclosure statement was eventually filed with the Secretary. An individual who contravenes this section is guilty of an offense and is liable to a fine of not more than $5,000. Candidates should be encouraged to review Section 147.82 so they understand the consequences of offenses relating to contributions.
The expense limits regulation outlines the expense limits for each year in the campaign period and provides the formulas for how the limits are calculated, including expense limits for local political parties, slates, and third-party advertisers. The regulation imposes expense limits to ensure equity in the election process so that some candidates do not greatly overspend relative to others. Again, while returning officers are not expected to provide specific advice to candidates about how to calculate their expense limits, you should be prepared to answer some high-level questions about the regulation and ensure that candidates understand they may need independent legal advice if they have questions about their obligations. Candidates should be encouraged to review the regulation, in particular Section 1, which explains the expense limits for each year of the campaign period and the formulas to be used in the calculation of expense limits for councillors and chief elected officials. Please note that expense regulation was recently amended to state that in respect of the 2025 election, the number of persons residing in an area at the start of the campaign period is to be determined using the 2024 Municipal Affairs Population List available on the Open Alberta website.
That concludes Module 3. Please remember to review our additional election resources online. If you have questions about school board elections, please contact Alberta Education. Updated versions of the MGA and LAEA can be accessed or ordered through the King's Printer, and questions about the elections database can be sent to our information services team.